Hi, and welcome back to another episode of HR Celebrity. Thank you very much to everybody who's joining us today. We have got a riveting show ahead. This is our episode 9. Very exciting. And thank you to everybody who's subscribed and who's joining us. Obviously, we're trying to build a community of people that are like-minded within the HR space. So thank you to everybody who has been following the progress of the show and who's joining us on a weekly basis. Today we've got rialize Jansen van Rensburg joining us from Rademeyer, Jansen van Rensburg attorneys. She is a senior partner there, and she is going to be talking about, can your employer unilaterally change the basic conditions of Employment Act, specifically speaking, your salary? So quite a big topic today, especially during the pandemic, during lockdowns, etc. Can your employer just go ahead without any consultation process change your salary? So we're going to get rialize on the line. Let's get her on the line right now. Awesome, Scott. Love it. And we have rialize. Rialize, welcome to HR Celebrity. Thank you very much for joining us.
Thank you for the opportunity.
It's awesome. So, rialize, before we start, tell us a little bit about Rademeyer, Jansen van Rensburg attorneys, and a little bit about yourself. Rialize, if you can, just go a little bit back on the camera. We're seeing just your chin. So, much better, but maybe a little bit higher up on the screen as well, please.
Okay, sorry about that. Is that better?
Much better. Thank you. Yes, so tell us a little bit about Rademeyer, Jansen van Rensburg, what you guys do, what you specialize in, and then obviously we can get into your topic, which I think is a hot one for this current time.
Okay, thank you. So, Brian, we're a law firm in Pretoria. We are located in Menlyn, Maine, so in Pretoria East area, but we do operate all over Gauteng, really, and we do have some clients that operate in Cape Town, Durban, so really all over South Africa. We specialize in labor law, especially myself and my partner, Kevin Rademeyer. We are the two senior partners of the firm. We do have some associates that work with us as well inside the firm, but we are a boutique law firm, Brian, and we specialize in labor law.
Fantastic. And your topic today, can your employer unilaterally change the basic conditions of Employment Act or your salary? And I think that's going to be quite a big one for our viewers today. Can our employers just go ahead and change our salaries or other conditions of employment? So what does it mean if we say that an employer can amend the basic conditions of employment?
Okay, so Brian, firstly, let us just distinguish quickly about the Basic Conditions of Employment Act and your employment conditions in totality. Now, the basic conditions of...
Oh dear, we seem to...
Sorry, Brian.
Oh, we lost you there for a second. So really, maybe we could just start that again. What does it mean? What does that mean? Let's go into the definition.
Okay, so Brian, like I said, we need to distinguish between the terms and conditions of employment that is contained in, for instance, the Basic Conditions of Employment Act, and between terms and conditions of employment that is written into an employment contract. Now, an employment contract, Brian, can never put you in a position that is less favorable than what is contained in the Basic Conditions of Employment Act. So, at the very least, those are the terms and conditions that you are entitled to in terms of your employment contract. But an employer can place you in a better position in terms of your employment contract than what is contained in the Basic Conditions of Employment Act. Now, for instance, Brian, when we refer to those kind of things, we refer to things such as leave, where the Basic Conditions of Employment Act has a minimum of 15 working days leave. You can get more in terms of your employment contract, but never less than that. Now, for instance, remuneration, which is one of the topics you mentioned specifically, that is not regulated in terms of the Basic Conditions of Employment Act as such. So remuneration is something that is negotiated at the outset of an employment relationship between an employer and employee. There are some industries, Brian, where it is regulated by the industry itself, so in a collective agreement, etc. But yeah, those are typically the
I
types
suppose
of
barring that of minimum wage.
Barring minimum wage, correct. Yes, correct. So minimum wage is also declared from time to time, Brian, as you're aware, by the minister in that regard. Now, Brian, there are various circumstances that might come about why an employer would want to amend your terms and conditions of employment. Often employers find themselves in a situation where they are facing financial difficulties or, other operational changes that might put them in a position such as COVID that we are typically faced with now.
100%.
That might place them in a situation where they need to relook certain conditions of employment.
So what are these circumstances? I mean, we've touched on COVID. Is there anything else specifically that you would like to bring up?
Look, Brian, generally in my experience, employers only embark on an attempt to amend employment conditions, such as remuneration, if they are faced with operational difficulties. For instance, and the most common one is financial difficulties, Brian. It often happens that an employer is in a position where they are investigating, possibly embarking on a retrenchment process, a Section 189 process. We commonly refer to it as a retrenchment process. Yeah. And prior to entering into that, they explore, as they have to by law, explore every other possible alternative that could be out there for them to avoid having to enter into such a process. And often one such alternative that they then attempt prior to entering into the process is to amend remuneration, to drop remuneration of employees.
And can an employer amend remuneration or other conditions of employment without an employee's consent?
No, Brian, you can never unilaterally amend any condition of employment. Well, let me put it this way. You can never unilaterally amend any contractual term, of which your conditions of employment are usually contained in your contract. Now, it's important that I state that, Brian, because later on I'll say a bit more about why it's important that we note the fact that it is contained in the contract. But no, Brian, it can never be done unilaterally. Now, Brian, it's usually done through a consultation process between the employer and the employees. And obviously, if there are unions involved in the workplace, the union must also be involved in those discussions, negotiations, and consultations. Now, Brian, the reality of it is at the time when an employer embarks on this kind of process, it is already faced with difficulty. So, the consultation process does not always have to be a long consultation process, but it can't be done unilaterally. There must be insights from employees, and they must be given an opportunity to give their, observations and alternatives, etc., to the amendment.
Is there any basic framework for a consultation process in terms of maybe you just have a detailed sort of understanding of exactly that? Is there a framework that we can follow, or is it very case-by-case orientated?
Brian, it definitely is case-by-case orientated. An employer has to be led by the circumstances, like I said earlier, that it is faced with. For instance, with the COVID situation, typically at the outset of the lockdown period, when it just all started and it was announced and we were all caught by surprise, various employers were faced with a situation where it needed to place employees either on forced leave, on unpaid leave, or whatever they were able to afford at that stage. Now, Brian, a lot of employees were also faced with a situation where were faced with a situation where they needed to drop remuneration. Now, because of the situation that they were in, that they couldn't necessarily have large consultations or many consultations, they needed to act quickly. And in such an instance, it was a much shortened consultation period to what we would usually, look at in a circumstances where we want to change conditions of employment. They needed to act swiftly. They needed to, speak to employees quickly. And as such, the consultation process was much shorter than usual. But Brian, like I said earlier, this could it could have various formats. For instance, in some instances, depending on how much the drop might be, you might get employees to understand and accept the change right at the outset. But typically what it would entail is, at the very least, the employer would need to kick off the consultation process by explaining to employees why this is necessary. I think that's the most important
And
thing.
I think, we can all understand that that's probably why it was a much shorter process during the pandemic, because everybody kind of understood what was going on. It wasn't sort of a surprise to any employee that, things have changed. There's a serious problem that all employers are facing, not just this specific company at a given time.
Yeah, definitely. Look, Brian, we're often faced with situations where employees do not want to accept it. They don't want to understand, or either they don't understand the reasons why it is necessary. And look, there are a lot of employers out there that also do take chances. So at the end of the day, it is important that employees be given an opportunity to state their case, if I can put it that way, in relation to the proposed change, and also to give, like I said, alternatives, etc., to the change. Now, Brian, it is important to note that if unions are involved, it tends to become a bit of a longer process, because the union has to be consulted, has to then be given an opportunity to consult with their, members, and then feedback with the employer, etc. It could be a go-around for a while, Brian.
Yeah. What if I refuse to accept the change?
Brian, the unfortunate thing is that, in a lot of instances, what a lot of employers do is, if an employee refuses to accept a change in the employment conditions, a lot of employers embark on a Section 189 process, a retrenchment process. Now, Brian, a piece of advice to employers is that I would tread very carefully in this regard. A Section 189 process can never be used to threaten an employee into accepting a change, of employment. However, Brian, if the operational requirements of the business is of such a nature, so for instance, it is in such dire financial position that it cannot carry on in its current operational format. So if employees don't accept the change, the business cannot carry on in its current format. Then the reality is that employees might be faced with a situation where the employer does enter into a Section 189 process, and it might ultimately lead to dismissals for operational requirements, Brian. But the short and the long of it is, you cannot be forced to accept a change, but you need to be aware that if you do not accept the change as an employee, then there might be consequences, in the sense that the business might be faced with a decision whether it can carry on in its current format or ultimately retrenchment.
I suppose, it's a hard conversation, but at the given time, it's those difficult decisions that a lot of employers are facing at the moment. And I don't think anybody's trying to go through 189s without really deep thought about it. Nobody wants their operations halted. A 189 is really the first step of, potentially going to the next step, which is ultimately closing down the business. So I don't think anybody really wants that. And I think employees should also be aware that, nobody takes those things lightly. Nobody wants to sort of take away the livelihood of people. And it's quite important to sort of acknowledge that sometimes. So
I think, Brian, one further thing I want to state there is that, like I said, there are exceptions. There definitely are employers that do take chances. But I think the general thing for employees to remember is, employers would not be approaching employees to say, listen, guys, we need to make a plan. We need to look at remuneration structures, commission structures, or whatever the case may be, if there wasn't a problem that they were facing. And I think the important thing, like I say to people in these processes, is not to look at it as an employee versus company kind of situation, but more a situation where the parties need to take hands and try and find a solution at the end of the day.
What should an employee do if they are faced with the situation and they are in disagreement to the change and they're now going through a 189 and they feel it's completely unfair? What is the step for an employee?
Well, look, Brian, firstly, let me say, if any employee is faced with a situation where their terms and conditions of employment have been changed unilaterally, so where they were not consulted with, where they were not taken into consideration as far as the change is concerned, they must immediately approach the CCMA or the bargaining council that has jurisdiction in their industry. A unilateral change is seen as a unfair labor practice, and therefore employees would have the right to approach the appropriate dispute resolution forum. If they are faced with a Section 189, like you've asked now, Brian, and they feel that the process or the reasons for it is not fair that is being undertaken, they feel that they want to stop it before it even finalizes, they can approach the Labour Court for an interdict, basically to stop the Section 189 process in its tracks. But Brian, that is unfortunately very costly, etc. So they can very much, after the process, also exercise their rights if they feel it was unfair by approaching the CCMA or the appropriate dispute resolution forum.
Awesome. Rialize, thank you very much for your time today. I think a lot of food for thought for everyone, really. I think we are faced with a situation where these sort of questions are coming up more and more. Thank you very much for sharing your knowledge. If anybody wants to get hold of you, I have put your email in the description. So if anybody needs any advice on labor law, or if they're going through any of these processes, challenges within their own company, they can contact you directly. So thank you very much for your time today. We really appreciate it.
It's just a pleasure, Brian. Thanks for the opportunity.
Thanks so much, Ed. Cheers.
Bye-bye.
That was Rialize from Rademeyer, Jansen van Rensburg attorneys. Rialize from Jansen van Rensburg, Rademeyer, Jansen van Rensburg attorneys. If anybody needs any advice on labor law, on disputes, etc., that you can get hold of her, and hopefully that was useful to you guys today. So thank you very much for everybody who's joined us, for everybody who's watching on a regular basis. Please remember to subscribe. We really appreciate it. We're trying to build a community through this platform. That is the purpose of this channel, is really just to bring HR to the forefront, to create a community where we can ask questions, we can get hold of experts, and we can showcase individuals as well as companies that are innovating within our space. So thank you very much to everybody who's joined us today. Really appreciate it, and we look forward to seeing you next time, where we have an awesome guest talking about EEE. Thank you very much again. Cheers for now.